legal services.
All right, so I just wanted to start by saying hello, and we will go ahead and get started. You'll see a PowerPoint presentation come up, and then we will basically be starting the presentation. All right, as I said, my name is Ray Gertkin. I will go ahead and begin the presentation. Please feel free to ask questions, but remember that nothing discussed here today is confidential, so do not include any personal details. But let's go ahead and get started. Before we move on, please be aware the information contained in the presentation is provided for educational and informational purposes only and should not be construed as legal advice or as an offer to perform legal services on any subject matter. This presentation will cover an overview of what record sealing does, the laws that govern how to seal records in Nevada, and focus on the 4 steps that you will need to undertake in order to seal your record. So first, what is record sealing? First, record sealing is not an expungement. Expungement essentially destroys the record, where record sealing limits access to the record. So expungement is not available in Nevada. Record sealing does allow access to certain entities even after the record is sealed, but with record sealing, the incident from the sealed record is deemed never to have occurred. So you can truthfully answer on an employment application that you have not been convicted of any sealed crimes. So record sealing restores some, but not all, civil rights. For that, you need a pardon, as pardons are the only way to restore gun rights in Nevada. Pardons also do not destroy or even limit access to the record. They simply remove the conviction, so a pardon record would still have to be sealed. Additionally, the Pardons Board has access to the sealed records and would unseal any sealed records to investigate a pardon application. So if you want to get a pardon, you must do that before you seal your records. But we are not going to talk about expungement or pardons anymore in this presentation. Instead, we're going to focus on how to seal your criminal records. The laws surrounding record sealing can be found at NRS 179.214 to 301. You can access statutes in Nevada online at the Nevada Legislature's website. The link is also in the description box below. Nevada's record sealing law is liberal and expansive. This means most convictions can be sealed, including serious felonies. There are important exceptions, including certain DUIs, such as DUIs resulting in death, crimes against children, sex crimes, and home invasions with a deadly weapon starting July 1st. But record sealing is all about providing second chances and aimed at helping individuals with records have access to housing and employment. The intent is to remove ex-convicts' criminal records from public scrutiny and to allow convicted persons to lawfully advise prospective employers that they have had no criminal arrests and convictions with respect to the sealed events. Now we're going to turn to the 4 steps to have your criminal records sealed. First, you need to go on a fact-finding mission to gather some of the records of cases you want to seal. You should start by going to the court where the case was prosecuted or the police department that arrested you if there was no court case. Some courts and police departments purge records, so be aware that you might not be able to get records for older cases. This is okay because the only record that you actually must attach to your petition is the Verified Criminal History Report. And that's the Verified Criminal History Report. We call it the CHR, but that's the official report from the Central Repository for Criminal History Report from the Department of Public Safety. You should, though, still try to get at least one other record from the court or law enforcement agency involved, because the CHR often does not have complete information, and it might be important to have the other record, which we'll talk about more in the next slide. But you should try to get records other than the criminal history report first, because you need to make sure that you are eligible to file the petition to seal your records before paying for and requesting the CHR. Once you have your CHR, you will need to fill out and file your record sealing petition as quickly as possible. Finally, when you obtain the order to seal your criminal records, you are not done. You still need to send that order to all of the agencies involved with your criminal history to notify them of the court's order and make sure that all of your records are actually sealed. All right, so now we're going to turn to the first of the 4 steps. Ashley, take it away.
All right, so like Ray mentioned, the first step is to gather the records that you're going to need to fill out your petition. And so Ray did touch on the CHR. So what is the CHR? It is a comprehensive criminal history for the state of Nevada. So what's going to be on that report is essentially any law enforcement contact you've had in the state of Nevada, criminal convictions and things like that should all show up on the report. It will have all of the information of things that have not been sealed yet. This is the information that the Department of Public Safety usually gives out when you get a background check and things like that, which is why it's important for us to use this report and other steps. So how do you get the report? You fill out a form called DPS 006, and you mail that form in with a money order for $27, as well as your fingerprints. We do recommend that you get your fingerprints taken at your local sheriff's office or police department because it does save a little bit of money. You can also find the form that we talked about, the 006 form, at rccd.nv.gov. And when you get your fingerprints taken, make sure you keep those fingerprints in the same envelope or however you received them. So if you get your fingerprints taken and they're in an envelope, don't open the envelope, don't mess with it. You just take what they give you and the money or your fill out form and you send it to the Department of Public Safety. We're going to talk about why you do probably need to get more records aside from the criminal history report in the next slide. So while the statute says the criminal history report is the only document you are required to attach to your petition, you still will want to get other records before getting your fingerprints and ordering the criminal history report just to make sure that you're eligible. You're only eligible to seal your criminal records if you've completed your sentence and the case is closed. Unfortunately, more often than not, that information is not included on your criminal history report. What we usually see on the criminal history report is something that'll say no disposition on file, or it just won't have a record of what happened after the arrest. So it is important for us to know the date that your case was closed so that we can figure out whether or not you can seal that record. If you still have your own records, you should first check with those. If you don't have your own records, you can go to the court that your case went through and you can ask the clerk's office for a copy of your criminal records. Essentially what we're looking at, once again, is something that shows when you satisfied all aspects of your sentence and when your case was closed. So some of the things to ask for would be a judgment of conviction to get the actual sentence. And if you entered into a plea agreement, those are really good things to get copies of as well, because that'll show what happened to the other charges that maybe were dropped as part of the plea agreement. If the court no longer has copies of your records because it's so old, that's okay. We just recommend that you'd ask what's called a purge letter from the clerk's office. What that does is it just shows that you tried to get the documents that you need, but that the court no longer has, retained those documents anymore because it is so old. Other things and documents that you might want to look at is if you went through probation and parole, you probably will want to get your discharge paperwork or documentation from the Department of Corrections showing when you were released. Essentially, once again, as long as you have something that shows when you satisfied all aspects of your sentence and your case was closed, you should be good to go.
And one thing that is not going to be on the slides, but we should probably mention, is that we also require sometimes people to get FBI background checks. And the reason for that is that when you order your CHR from the Nevada Department of Public Safety, you are only getting your Nevada records, right? So on the actual CHR, it may indicate that it is a multi-state record, which clues anybody looking at that there are criminal records or activities from other states. And so to make sure that you are certifying that everything in your petition is accurate and that you are actually eligible to seal, you may want to consider getting an FBI background check if you have criminal records from other states, or if your Nevada criminal history indicates that it is a multi-state record. But just to keep in mind that sometimes we do, if you are coming to us for assistance, we might require that.
Yes, very good point. So we mentioned, okay, well, eligibility. So now we're going to talk about when you are eligible to ask the court to actually seal your record. So as we discussed briefly before, in order to be eligible to seal your record, you must first satisfy all conditions of your sentence. So the time that we're going to be talking about, the waiting period, actually starts from the date that you were released from actual custody, or when you were discharged from probation or parole, or when you're no longer under a suspended sentence. So essentially you have to look for the date that your case was completely closed, which is why we were talking about those other documentations. Once you're discharged from probation or parole or released from custody, then that clock starts ticking. During that time period, you do have to remain conviction-free. Looking at convictions now, not arrests, and also, traffic tickets, things like that, that doesn't count as well. So you have to remain conviction-free during that time period. If you have multiple convictions that are close together in time, you can still file one petition in district court to have those convictions sealed. All of the relevant time periods have to have run, and the judge is going to take your entire criminal history into account, though, when considering whether or not to seal your record, including previously sealed convictions. You also cannot have any charges pending, because the goal of record sealing is essentially to give people who've stopped committing crime a chance to move on with their lives. Okay, so when we talk about the waiting period, the first step you're going to want to do is determine the category of your conviction. It's really important to remember that this is the conviction and not what you were arrested for. Oftentimes we see people are arrested for one thing and then convicted of something entirely different. So the waiting period is based on the conviction. If the court does not indicate it, you can call the court and use the case number to try to figure out what the conviction is, or sometimes you might even see like the criminal statute and you can use that to look it up on Google and try to figure out the level. But the wait times are measured based on the conviction. So for example, a misdemeanor, most misdemeanors require a 1-year waiting period. A misdemeanor DUI and DV charge requires 7 years. Gross misdemeanors, 2 years. An E felony is 2 years. Category D, C, and B felony all require 5-year waiting periods. And a category A felony and residential burglary requires a 10-year waiting period. If, however, the case was dismissed or you were acquitted, there is no waiting period. So if you were in a criminal case yesterday and that case got dismissed yesterday, you could file your petition today. If the prosecutor declined to charge you, though, then no wait period if you have that in writing, or you might have to wait for the statute of limitations to run. Obviously, what they want to make sure is that the prosecutor isn't just waiting to charge you, like gathering evidence against you still. You won't be able to seal your record if that's the case. But if the prosecutor in writing says, nope, we're not going to charge this person, then you should be okay to seal it. Okay, so some special considerations. So if you went through a diversion program, so if you've attended a court-ordered counseling, substance treatment, or work program, the records may actually already be sealed. In Nevada, many court-ordered programs will automatically seal a record upon successful completion of a diversion program. If you've completed such a program, make sure you review the court order that states you've completed the program and see whether it says the record should be sealed. This is really, really important. You should provide the Department of Public Safety with a copy of that order just to be safe. We'll talk a little bit about what to do with orders sealing records, but when in doubt, don't assume the Department of Public Safety has been made aware that this record has been sealed. You should send them a copy of the order and tell them, hey, you need to comply with this order. Another consideration is successful completion of a reentry program under NRS 179-259. It says it reduces the wait time to seal the record down to 4 years. So that might make it easier for you to seal a record or make it so that you can seal it sooner. There's also a 3-year time frame for drug offenses, not for the purpose of sale. If complete terms and conditions of the court, if you complete the terms and conditions of the court and you follow probation and parole, and at the hearing it's determined that you've been rehabilitated, or if it's automatically sealed if your probation is completed. So it's just another consideration to think of, what was I convicted of? Did it involve drugs or a sale of drugs? And can I maybe fall under one of these special considerations? The records sealed under these 2 statutes, though, may be open to inspection by licensing agencies where normally sealed convictions would not. So it's one of those things where this is something to keep in mind and look to see if maybe it makes it so that you can seal your records sooner, but also recognize that going through the traditional record sealing process that we're talking about today does provide additional protections that's not provided under these 2 circumstances.
Okay, so next we're going to talk about filling out and filing your petition. Once you've determined your criminal records are eligible for sealing, you can fill out and file your petition. We can provide you with blank forms and instructions, as well as determine if you're eligible for our assistance, so feel free to contact any one of our statewide offices. Our contact information is on our website at nlslaw.net. When preparing your petition, it is extremely important that you pay attention to detail. Everything in your petition must be complete and accurate. Include any aliases you may have used, the PCN number for each charge, and this is located at the top of each individual record on your CHR. Make sure all dates are correct, the case number matches. You list out all of the arrest offenses as well as the offenses that were actually charged. You also need to list out each agency that you want to receive notice that your record has been sealed. Also be aware that there's a filing fee unless you file and are eligible for a fee waiver. You can get the appropriate fee waiver forms from the court that you need to file in, or you can go to selfhelp.mvcourts.gov and they have generic and standard fee waiver forms. We cannot stress enough how important it is to pay attention to detail. Everything in your petition has to be accurate, because if it is not, the Department of Public Safety might contact you after you've received the order from the court and tell you they cannot seal your record. So it is extremely important. We're going to talk about this a lot, but all of the information in the petition needs to be accurate, and you need to make sure it all matches. But here, if you go on our website at nlslaw.net, and if you click on the Know Your Rights criminal record sealing tab, you'll see that we have some forms and instructions on how to complete your petition. So this is just the first page of the petition to seal records, and you can see how much detail that we suggest you put in your petition. It's extremely important that you try to be as accurate and as comprehensive as possible. Another thing that you'll want to attach to your petition is a declaration. And this is because, remember, the judge still has discretion on whether or not to seal your record. So they're going to look at your entire criminal history, your petition, and anything you attach to your petition to determine whether or not your record should be sealed. Now, technically, the law says there is a presumption in favor of sealing your record as long as all of the requirements of the statute are met. And that's waiting the time period and having your sentence be complete. But it's still a good idea to make sure that you provide a basis for the court to seal your record. So we suggest you attach a declaration to it that lays out, some of the reasons that you want to give the judge and how you've turned your life around. Or any, specific factors about the crime itself. If it was a simple misdemeanor that you committed 10 years ago, obviously I think that's going to be a little bit different of an explanation than a significant felony record. All right, so after you file your petition, you will want to send a copy of it with a request for the prosecuting attorney involved to sign a stipulation, which is an agreement to seal your record. It is extremely important to send the stipulation to the prosecuting attorney's office. Getting a signed stipulation from the prosecutor will speed up the entire process of sealing your record and make it easier for the judge to sign the order. If you're sealing your record, multiple records, sorry. Each prosecutor that has authority over the court or the charges will need to sign a stipulation. So if you have, say, a municipal ordinance violation plus a misdemeanor in state court or a felony in state court, then you want both the city attorney and the district attorney to sign a stipulation. And that's basically the attorney's jurisdiction. So district attorneys have jurisdiction over felonies and misdemeanors in state court, and city attorneys have jurisdiction over municipal ordinance violations in a municipal court. Once you get all of the stipulations filed with the court, you'll need to file a request for submission and attach a copy of the proposed order to seal your records for the judge to sign. So what happens if the prosecuting attorney decides that they don't want to sign the stipulation, or they file, we'll talk about an opposition a little bit later, but I'll go ahead and mention it now. But most of the time what's going to happen is that the prosecuting attorney probably just will not sign the stipulation and send it back to you. If that happens, you'll just need to file the request to submit 30 days after you've attempted to get the prosecutor to sign the stipulation. The request to submit lets the court know that your case is ready for a hearing. And do remember, if you have a stipulation signed by all the prosecuting attorneys, the judge can just sign the order without a hearing. If the prosecutor does not sign the stipulation, though, or there's an opposition or something else is filed, then a hearing is required for the judge to sign the order to seal your records. If you are in Washoe County, please be aware that there's a local rule that says the prosecuting attorney has 21 days to sign the stipulation. So you actually only have to wait 3 weeks if you're in Washoe County to file that request to submit to get a hearing before the judge. All right, so here's a brief recap of what we've gone over. So we talked about gathering your required documents, filing the petition, notifying the prosecuting attorneys and sending the stipulation, and then waiting for the responses from the prosecutors. What are the responses? Well, I mentioned that the prosecutor might send an opposition, which is basically the request from the prosecuting attorney that the judge not sign your record sealing order. So if the prosecutor does that, that means that they're not agreeing, and you will have to have a hearing and explain to the judge at the hearing why you should have your record sealed. The prosecutor, though, could just agree to sign the stipulation, send it back to you. You would file that with your request to submit in order for the judge to sign the order without a hearing. Or the prosecutor does nothing, and then you need to file the request to submit to get the hearing before the judge. And then step 5, there's actually a hearing or the submission for the judge's decision. If a hearing is scheduled, you'll have to show up in court for your hearing and tell the judge why you deserve to have your record sealed. You would also want to bring any other additional evidence or documents to support your petition at that point in time. It's extremely important that you be prepared for your hearing when it's scheduled. And then the final step, which we're going to talk about next, is sending the order out to the various agencies. So before we get to that, I did see that there was a question on the live stream about what is sort of the current status of the courts and what happens when the court is closed, essentially, and you need to file your petition. Right now, the Las Vegas Justice Court, I believe you can still e-file. So my suggestion would be that you e-file your petition and then go ahead and submit the stipulations to the prosecuting attorneys. I am not sure, honestly, if you can actually walk into the Las Vegas Justice Court, but I know they have electronic filing. So I would suggest that you sign up for an electronic filing account for Las Vegas Justice Court and see if you can e-file your petition. If it's Clark County District Court, same thing. They require e-filing as well. And so you would want to file your petition online. And that way you can actually file it and actually start the process. Because while you might not get a hearing right now, it is going to take you a while to send the stipulations to the prosecuting attorneys, wait for them to respond or not respond, and then file the request to submit to tell the judge that you're ready for the hearing, that's going to be a little while down the road. So I would suggest you try to e-file right now and not actually walk into the court to try to file. Because I know in Washoe County and Reno, the courts, I don't know that they are open to the public right now. Yes, if you don't need a hearing for yours, then I would suggest e-filing, getting the stipulation signed by the prosecutor, and then filing the request to submit with the proposed order all online and see if the judge still signs it. I mean, the judges are still working. There's still hearings. There's still emergency sorts of hearings and other things that need to still happen. So the judges are working. So if you can get that e-filed, that's what I suggest you do. Okay. Once you get the order signed by the judge, though, your case is sealed, right? But you still have to notify each agency that has a copy of your records that the record has been sealed. Otherwise, the information is still viewable to the public. Copies must be mailed to each law enforcement agency that has a copy of your record. Some agencies may require a certified copy. Those certified copies can be expensive unless you have filed and been approved for the fee waiver. It's a good idea, though, to get at least 10 certified copies of the order, although you certainly could call the agencies and see if they require a certified copy first. But you do want to keep at least one certified copy for yourself in the event you need to send an additional copy in the future. Remember, once your record is sealed, you cannot even access it. It is completely hidden from public view. When we file record sealing petitions on behalf of petitioners, once the record is sealed, we can't even access it. So once it's sealed, the record is gone. You want to make sure you at least keep one, maybe two certified copies of that order for yourself. But the first thing you want to do when you get a copy of the order is send it to the Department of Public Safety, Records, Communications, and Compliance Division. And here's the address that you want to send it to, because the main department that needs to know that the judge signed the order is the Department of Public Safety. When people, employers, landlords request a background check, normally who they're looking at to get the background check from is the Department of Public Safety. So that's the agency that you need to focus on the most. And once you receive compliance that they have sealed your record, generally speaking, it's probably okay to run a background check. But you still also, though, want to send your orders to all of the other agencies that you've listed on your petition, which you'll see if you look at our standard petitions, we have a lot of spots for you to put in agencies. So you want to send it to the police or sheriff's office that arrested you, the prosecuting attorney's office, probation and parole if you're on probation or parole, and the Department of Corrections if you were in custody in prison. So essentially any agency, including the DMV if it was a driving related charge, so that the agency knows that your record has been actually ordered sealed by the court. Without your providing that notice, they're not going to know, and they're not really under an obligation to seal it if they haven't received notice. So it's extremely important that you mail all of those orders out once you get them back from the court. And remember, as I said, once sealed, the records are not viewable to the public or the potential employers in most cases, but there are some exceptions. So there are certain individuals who can still see your criminal history once you've gotten your orders to seal it. The Nevada Gaming Control Board may inquire into and inspect sealed records if the event or conviction was related to gaming. So essentially, if you apply for a gaming license or you apply to work at as a gaming employee, you are required to get a license or go through a background check with the Gaming Control Board, and they can access sealed records. Another agency that can access sealed records is the Division of Insurance of the Department of Business if you are applying to get a license to sell insurance. And then there are some other agencies such as prosecuting attorneys, the Department of Public Safety, the State Board of Pardons, commissioners can all request access to sealed records in limited circumstances. And remember, judges can always access sealed records as well. All right, but that basically does it. Thank you for attending. I will go ahead and check the live chat again to see if there were any additional questions. Please feel free to put a chat if you have a question into the live chat box now, and we will definitely try to get to it if we have time. Yes, it is very frustrating right now with the courts and everything that's happening. I definitely appreciate everyone's frustration. And I certainly understand that it's important to have your record sealed if you're eligible right now, especially with all the difficulties with getting jobs. It's definitely a time to make sure that once things open back up, you're essentially ready to go. But please feel free to contact any of our local offices if you would like to see if you qualify for our assistance. As I said, you can also look at our website at nlslaw.net to access some more information and our forms. But I have listed up here all of the phone numbers to the various offices. And yes, this will be kept online. We will have this on the YouTube channel once the live stream ends so that you can go back and watch it. Any other comments, Ashley?
No, that's about it. I guess the main thing is, yeah, if you have any questions, don't hesitate to give our office a call, or if you want copies of our pleadings, we've also put together an instructional packet that basically goes over all of the same information that we went over during this presentation, but it is in like a packet form. So if you want us to mail that out to you or email it to you, don't hesitate to give us a call and we'll get it, all the information that we have your way. And we do give these presentations live and these classes live. And so sometime in the future, when things settle down, I'm sure we'll be doing that again as well. So keep an eye out on our events tab on our website.
So there is another question about whether administrative fees can essentially prohibit the record sealing. So we're talking about when the clock starts ticking essentially. And it's my understanding that fees do not affect the completion of your sentence, essentially. But with that said, you really do want to get a copy of that local record, so that court record, to see whether or not the court closed it or discharged you from probation. Because if that's the case, then that's fine. As long as you have a record that says your case is closed or your probation has ended, then the clock has started to tick as of that date. And you can, as long as you wait the required time frame, file your petition. But it is my understanding that administrative fees don't affect the closure, the completion of your sentence, because your sentence is really paying fines, maybe, going through a period of probation, checking with your probation officer, maybe paying restitution. That's really the sentence, but anything that's going to prohibit you from being discharged from probation is going to be a problem. And I know that sometimes people are dishonorably discharged from probation. We didn't really talk about dishonorable discharges, but you can still seek to seal your record if you were dishonorably discharged from probation. Again, that discharge date is the date that starts the clock. But a dishonorable discharge simply means that it might be a little bit more difficult for you to seal your record, in the sense that there is a presumption under Nevada law that if you meet all of the statutory requirements, your record should be sealed. Now, that can be rebutted by the prosecutor, and we've talked about the prosecutor filing an opposition. So essentially, you are not entitled to that presumption in favor of record sealing if you're dishonorably discharged. You really want to make sure you beef up your petition more, have a lot more evidence from your supporters and people in the community indicating how you've turned your life around, but you can still seek to have your record sealed if you've been dishonorably discharged. It's just that discharge date is the important date for the timeframes to start, and then waiting the appropriate timeframe and then filing your petition. All right, so if so the waiting times again are, you have to be conviction free in order to be eligible to seal your record. So if you have a conviction, let's say it's an e-felony, so it's 2 years, and you get another conviction within that 2-year period, you technically are not eligible to seal that felony. So if you wait the time frame then for the second conviction, you can now file one petition in district court listing all of your records. So the judge, though, is going to look at your records and then can agree to seal essentially all of those charges, but you would have to wait until the most recent conviction, the time has run. Actually, all the timeframes have essentially run at that point in order to be eligible to seal your records. So another thing is you can't have any pending charges in order to seal your record. And we really do not advocate picking and choosing what you're going to seal. In the past, you used to be able to, it was actually required that you file a separate petition for every charge. And when the law first changed, it was still a question about whether or not you could file one petition to seal an entire criminal history, or if you had to seal sort of convictions that interfered with the timeframes of other charges. The Court of Appeals from the state of Nevada recently came out with a decision that made it clear that you can file one petition to seal your entire criminal history, no matter if there were issues with timing. You do have to wait for all of those timeframes to run. But once you file the petition, the judge is going to then have the ability to look at the totality of your circumstances and decide whether or not to seal your criminal history. All right. Also, please feel free to, as Ashley said, contact us. We can send you any of the sample pleadings or the instruction manual. Also, you can look on our website for some of this similar information that we've gone over today. And then we will, as she said, try to do this again. So if, once also things open back up, we do have these classes in person in our Reno office. And we also offer these occasionally in the rural communities in Northern Nevada. And I know our Las Vegas office also does presentations, I think with UNLV on record sealing. And so there are a lot of options and avenues. You can contact any of our offices to kind of get a better idea of when these educational presentations will start happening. But our offices are closed to in-person visits. We are working remotely now, so please feel free to email us, call us, or visit our website. And then obviously this presentation will also be on our YouTube channel that you can review. We will save it on the YouTube channel, so you can review that once the presentation is over if you want to, if you felt like you missed anything. But at this point, we'll go ahead and say thank you guys for attending, and have a safe week. And we thank you so much for being interested in supporting Nevada Legal Services. But again, thank you.